All right, check, check, 1, 2. All right, good afternoon, ladies and gentlemen. Welcome to the monthly meeting of the City of Des Moines Zoning Board of Adjustment. This board has the power under Iowa law and the zoning ordinance of the City of Des Moines to hear and make decisions on requests for variances and exceptions from the regulations in the zoning ordinance, to review conditional use requests, and to consider any appeals from the decision of city staff in their administration of the zoning ordinance. The members of this board are citizens of the City of Des Moines. They have been appointed to this board by the City Council. The board members are volunteers, and they receive no compensation for their public service. I'm going to take a moment to introduce our board members. On the audience's far right is Tom DeCio. Next to him is Dave Gare. Next to Dave is Rhonda Cedillo. On the audience's far left is Heather Ann Rowe. Next to her is Kuku Sa and Marlis Jones. My name is Mel Pins, the board chair. I'll introduce our city staff who will be assisting us today. To my left is the zoning board's legal counsel, City Attorney Gary Guidelock. Our staff that will be assisting down here on the sidebar to the audience's left. That includes Frank Dunn Young, Senior City Planner, Bert Drost, Deputy Planning Administrator, Jesse Torres, Zoning Enforcement, and Chris Heilscove, the Zoning Enforcement Officer. Assisting us with our meeting moderation, kind of running the audio video behind the scenes, is Monica Vasquez right here just to my front. I'm going to cover our meeting's procedure here, just a brief summary. For some of you, this may be your first time in front of the Zoning Board of Adjustment. You may hope it's your only time. But we will help you through the process. So I'll give you a little background here, but at each step of the hearing, we will help you with what happens when. So don't be nervous about that. First and foremost, the Zoning Board of Adjustment is a quasi-judicial board. This hearing will be conducted within the procedures and format as is authorized by Iowa law and this city's ordinances. The meeting is open to the public. The meeting is being recorded by both audio and video for a legal record of these proceedings. The board members have each received a copy of the agenda and the staff recommendations. And by the way, if you don't have a copy of our agenda for today, it's in the little black tray here just as you would have come in the door. So when I'm done with my opening remarks, feel free to step up and grab a copy of our agenda. The board is required to base its decision on each item upon the criteria established by law for the type of relief sought by the applicant. The law applicable to each case has been identified in the written staff report. If the facts, as determined by this board, demonstrates that the criteria established by law for granting the relief has been satisfied, then the board must grant the relief. Otherwise, the board must deny the requested relief. Each item will be announced in the order that it appears on the agenda. Items listed on the consent portion of the agenda, which is our first section of the agenda, are not planned to be individually discussed. Rather, they will be considered for approval in accordance with the recommendation in the staff report, unless either the appellant does not agree to the conditions that have been recommended by staff, or if there's a member in this audience or a member of this board that requests that the item be removed from the consent agenda so that a full discussion on the matter can occur before a decision is made. And I will come back to that in just a few minutes on the consent agenda, and I'll poll the audience if there are any concerns. For the regular portion of the agenda, after an item is announced, the city staff will give a brief overview of the appeal, and they will present any written comments that have been received prior to the hearing. Then the appellant or their representative will be allowed up to 10 minutes to present their appeal. We'll then move to the public comment portion of the hearing for that agenda item. Anybody that wishes to speak in support of, in opposition to, or even in neutrality of an appeal will be allowed up to 5 minutes each to provide their comments. This will be their one and only opportunity to address the board regarding the item at hand. Once all concerned citizens have spoken, the board will then ask any additional questions of city staff. Lastly, the applicant will be given 3 more minutes for a rebuttal or other closing comments if they so choose. All speakers must speak only from the podium. You must give your presentation by giving your complete name and address of business or residence as appropriate. In the event, you may need to be contacted for legal notices related to the outcome of this appeal. And I believe we also have a sign-up sheet there at the center podium. If you do approach the podium, we'd ask that you just quickly write your name and address down. All speakers are requested to remain courteous, to focus their comments only upon those facts that demonstrate whether or not the criteria established by law has been satisfied. Speakers are also asked to remain courteous and to be respectful of time considerations, because if necessary, the board chair will limit further comments by a speaker if they exceed their time limitation. After all comments have been received, the board chair will then close any further public comment on the agenda item, and the board will immediately deliberate the request, and we will make a decision here today on the appeal. Please note that it always takes at least 4 affirmative votes for any zoning appeal to gain approval. If your appeal is approved today, we'd ask that you wait until about at least a week or so from today's hearing if you'd need to contact the city's Permit and Development Center to obtain any necessary building or sign permits that are related to your appeal. This will allow the decision of this board to be documented in the form of a decision and order. That document will be provided to you and city staff for the record. Any appeal that is approved by this board must be implemented, constructed, or otherwise utilized within 2 years of the date of the board's decision, or such approval shall expire. Finally, the decisions of this board can only be appealed in the Iowa District Court. So if you believe you've been harmed by an error that you believe has been made by this board, your only remedy is to seek relief through the court within 30 days of the filing of the board's decision and order. If you believe the zoning regulations applied by this board are wrong, you may petition the City Council to change those regulations, but only for future considerations. Any material written or otherwise used today as part of any presentation is considered part of the permanent record. So if there's anything you want to present today related to pictures, drawings, or documents, you may do so, but you'll have to give appropriate copies to city staff for the record if you have not already. If you would like copies of anything presented today, just ask city staff after the hearing and they'll assist. Finally, just some quick housekeeping items. Please avoid any undue conversation in the audience so as to limit distractions during the hearing. You're doing a fine job. Please ensure your cell phone's been silenced. Also, so far, so good. And if you need to use a restroom, you can just leave through these doors, go past the staircase. You don't have to go back downstairs. There's restrooms on the left, just past the staircase. Once the agenda item you're interested in has been completed, you're welcome to leave the meeting. We will have a 5-minute break in the meeting around 3 o'clock or so if needed. And we also have one member of our board that has a special appointment and they need to leave today around that time as well. So what I'm going to do here, as I noted, we're going to look at our consent agenda. And I think I'm going to have Frank help us just review quickly to see if there are any changes to that. We have 4 items on the consent agenda, and then items 5 through 9 on the regular agenda. Any changes, Frank?
Good afternoon, Chair, members of the board. I did receive a call from the applicant for item 4, located at 2715 Douglas Avenue. The applicant, Alley Landing, is requesting a type 2 zoning exception to install a 2-foot by 13-foot, 26 square foot backlit wall-mounted sign, which would be placed above the 3rd floor. And so that requires a type 2 zoning exception. The applicant is looking at an alternate sign design and was requesting that we continue it for a month so they could go back to the drawing board and see a different proposal that would be more suitable for their location.
Okay. Unless the board members have any questions of Frank about the request for the continuance, would there be a motion by one of the board members to allow for continuance of item 4 to the next regular hearing? So moved by Marlis, second by Rhonda. All those in favor, raise your right hand, say aye. Motion carries 7-0. Okay, if those were our only changes, then we have 3 items on the consent agenda, and I'm going to go over those just very briefly as a group. These are items that have requested either conditional uses or zoning exceptions. City staff believes that the requested items have merit, and based on city staff recommendations, staff has recommended approval. So if there's somebody here in the audience that would not be comfortable with this board granting approvals of items 1, 2, or 3, I'm just going to read through them quick. Just raise your hand if you'd be in opposition to this board granting approval on items 1, 2, or 3, and then we will open the hearing for any specific item and listen to concerns with the request. So item 1 is a zoning exception at 2136 University Avenue related to some freestanding illuminated monument signage. Is there anybody here in the audience that would be opposed to the board granting the requested exemption subject to staff recommendations? Item 1. Okay, seeing no hands. Item 2 is a conditional use request at 4505 Douglas Avenue to convert existing building to an assembly place of worship use. Staff again is recommending approval subject to a few conditions. Is there anybody in the audience opposed to granting that conditional use? Just raise your hand if so. Okay, seeing none. Item 3, a zoning exception request at 1150 Locust Street from Nationwide Mutual Insurance related to installation of signage, including maximum allowances for signage and height-related restrictions. Is there anybody here opposed to the board granting the requested exemptions on item 3? Seeing no hands, board members, unless there's any concerns, would there be a motion to grant approval of items 1, 2, and 3? Motion by Rhonda, second by Marlis. All those in favor? Okay. All right, motion carries 7-0. So if you were here for items 1, 2, or 3, they've been approved, subject to staff recommendations. And as I mentioned, in about a week, you'll get a copy of that approval in a form of a decision and order document. And then you can come down if you need to apply for any construction or sign permits. So if you were here for items 1, 2, or 3, those have been completed. So we'll let everybody get readjusted here for a moment, then we'll move to our regular agenda. And we'll start with item number 5. This is an appeal of an administrative decision by the zoning enforcement officer in the vicinity of 1000 Thomas Beck Road. Our procedure for an appeal of an administrative decision might be a little different. I might need a reminder on that so we can help everybody with that, but we're going to have Frank kick us off with some assistance from Chris Heilscope.
Okay.
Aha, cool.
Right there. It's not in there.
Thank you, Frank. It's extremely helpful.
Okay, good afternoon. Chair, members of the board, Chris Husko, Zoning Enforcement Officer. We're here today listening to a matter at 1000 Thomas Beck Road in Des Moines on the south side. Present some evidence or exhibits here. This is just to the south side of Grays Lake. The business is currently being used as MedShred and the Shredder Paper Recycling in an NX1 zoning district. I want to discuss real quick some terminology today that's important for the board to understand. First is a certificate of occupancy, and what that is, it's issued to new construction projects when they're finalized. And the next one is a certificate of zoning compliance, and that's issued on existing sites for change of use. And then also the site plan. The reason those are important for the board to consider today is because those documents are what we use to legitimize or lawfully establish a business. In this case, the medical processing recycling has not been established that we can determine at this point. Move on. Okay, on or about October of 2024, the city had the applicant, Mr. Benskin, in for a pre-application meeting. At that point in time, he had presented a plan to rezone some of the property right out in here for mixed-use residential and also expansion, moving a metal building from another property to expand medical recycling. At that point, our planning staff asked us for a zoning determination on that medical recycling. What you see there is our zoning determination letter. Lists the zoning district. On number 3, they're based on evidence from both the property owner and the owner's website. MedShred is operating within the junk or salvage yard classification as described in Chapter 134, 3.64 of Municipal Code. Therefore, it's a violation, and it's cited on a notice of violation. So MedShred has no legal nonconforming rights, as the use would have been prohibited under the retired code of M1. So what that is the warehousing use for the paper recycling business was lawfully established, but the medical recycling MedShred business was not lawfully established. That would fall under our use category of a junk and salvage yard. Just to make that distinction very clear. And number 6 states that the Municipal Code of the City of Des Moines, no land shall be occupied or used in whole or in part for any purpose whatsoever until a certificate of zoning compliance is issued by myself, stating the land use comply with the provisions of the zoning ordinance. Here we have a copy of our inspection staff. I should introduce Jesse Torres as the inspector on this case, has joined us today and would be available for specific questions if needed. Here we're citing Chapter 134, NX1 District. From the table, principal use and accessory uses of the municipal code. And there is a prohibited use that has been cited of junk and salvage yard. It goes on to list some other uses there, but we're primarily focused with junk and salvage here at this location. This is an additional notice that isn't really relevant to our case today. It's more about site plan issues at the site. As you're working through your packet there, got some photos of the location. Further down here, this is a certificate of occupancy that was issued back on 2/11 of 1998. And we do have it documented there in M1 as a warehouse and office. And that's particularly important in this case because nowhere in there is junk and salvage listed, and that use is not an approved use. So in our old retired code prior to December 19 of 2019, I believe, the M1 zoning district is more of a light industrial, which would not allow a junk and salvage. That would have came before the board for a conditional use approval, just like it would today in our junk and salvage category. And to date, that has not happened. That's really the rationale behind issuing the zoning determination letter the way we have it. Provided the code here from pre-2019. Under 134, 155, it talks about non-conforming uses. Keep in mind, those have to be lawfully established, and that would be one of those issued with one of those three documents that I previously mentioned. In this case, that junk and salvage was never issued here. So they're okay to run the warehousing component of the business, but not the medical recycling. Additional exhibit here is provided. This is one of the original site plans. I think in our packets we've included some other ones from other submittals at pre-apps. Clearly lists M1 and does have office and warehouse use listed on there. We have had an opportunity to meet with Mr. Benskin and go through options here. As detailed with some of these case notes we're providing, relevant discussion is talking with potentially removing this use, maybe working with our economic development department. To date, that hasn't happened. So we've had lengthy discussions, very familiar with the development services process for legitimizing businesses. In the packet today, we've got several examples of pre-apps that the property's gone through. And I just take note here for the sake of time that on each of those pre-apps in your packet, a medical waste and recycling use has never been legitimized lawfully. There's a period of vacancy in these photos. 2014 water department use. This is some marketing material provided. I think this was obtained off of the internet of what MedShred actually does in the process. This also helped us in determining our rationale for putting it in this use category. You can see some of the uses there. Identifies the property as 1000 Thomas Beck Road in Des Moines. And these are some notes from our pre-application meeting that our development services staff conducts. And in about every case, there's a use determination that's made prior. During that meeting, the zoning enforcement department will make a use determination. So in this case, if we scroll down to the planning department and their notes, and this was from October of 24. Apologize for all the scrolling here. Looks like our planner, Shauna Barron, was in charge of this one. Lists the zoning again as Annex 1. That's just a mixed use residential type neighborhood that's currently there. In number 2, it's particularly important in helping the board make a decision and to uphold our determination here. The use proposes to be location of a metal accessory building for security company that processes paper shredding and medical waste disposal. This is the first time you'll see in any of our pre-app notes where that use shows up. I think adding credibility to there not being a lawful established use as a junk and salvage category. These are additional pre-app notes from Mr. Benskin's proposed new development of 130 townhomes and conversion of existing building for clubhouse. In there, there's nothing that lists a medical shredding business. This was an appeal before this board back in 2013 for a restaurant, it looks like, that was approved but never acted on. And we do have some copies of communication in here for the board to review, where they're contesting our use category determination here. Would just pay close attention to a legal non-conforming use must be lawfully established. And that's our position on this, is that medical waste recycling and processing was never lawfully established with a CO, a COZC, or noted on any of the numerous site plans that have been submitted or any of the pre-app minutes. Communication between our attorney and again a copy of the zoning determination letter that we provided. And with that, I would be happy to take any questions, or Frank, according to that agenda item, is that appropriate?
Board members, anybody have any questions for Chris? Heather? I'd be amiss if I didn't have a question for you or an applicant. I'm familiar with this location. I remember the 2013 when Bill Gray was our chair at the time. But just to review a couple fundamental things here. As this is an appeal of the zoning officer's determination, the board isn't here today to determine if we want to allow the use or give any appeals or conditional uses. We're just here to listen and determine if we believe you were correct in carrying out your duties in the code to determine it's in non-compliance. Is that correct?
That is exactly correct.
Okay.
The code,
And I would like to weigh on that because
Sure,
I do
please
think
do.
that's more of a legal question as to what the standard of review is, essentially. And the chair is correct. This is a review of whether the zoning officer's determination was based on evidence presented before him, and whether that decision was arbitrary and capricious, which is the standard that the board would look at. And the reason I wanted to speak on that was to remind the board that in its consideration today, it's looking at the materials that were available to the zoning enforcement officer when the decision was made, because anything that was not part of that wasn't presented to him or available to him during the decision-making process wouldn't be properly reviewable.
Thank you both for that. Appreciate the clarification. And related to the issue at hand, I see the definition of junk or salvage yard, and it seems to be, there's kind of a focus on the medical waste aspect here, but do they also offer like document paper shredding services?
yes, I believe they do. There's another business in there called the Shredder that does that exact thing.
And if I'm following along correctly here with what the ordinance allows for use in the district, junk or salvage yard, if anybody is dealing with waste or scrap that can even be paper, that's not allowed by right either, correct?
Right. The processing really shouldn't be happening at the site. And in some of our notes, we've had kind of determined that wasn't happening at the site.
Okay.
But the warehousing is lawfully established, just to be
Okay.
clear. So yeah, if you're in the code, it says waste, and that means processing, handling, distributing, hauling. All of those things would constitute that medical waste falling in rationale, adding to the rationale that it falls into junk and salvage. May not be a traditional definition that we all think of in common terms of scrap metal or old cars. It can be all encompassing with any item of those natures.
Mm-hmm. And medical waste might certainly have some nasties in there I don't want to describe, but it can include things like paper, rags, bottles. That can be part of medical waste as well, correct?
Yeah, I believe. And in our description in the packet there it goes into pretty good detail about
Okay.
what they would be handling there.
Okay. All right, well, those are the only questions I have for the moment. Anyone else? Okay. Okay, so the appellant that disagrees with the zoning enforcement officer's determination, they have an opportunity to address the board. And you'll have up to 10 minutes to do so. And if there's two of you that wish to speak or kind of tag team on this, you've got 10 minutes to share. We just need you both to sign in, and if you can, give us your names and addresses as appropriate here. We'll give you a moment to get situated.
Good afternoon. My name is Mackenzie Moreno. I work at Brown Winnick and represent Thomas Beck 1 LLC, which is the applicant today. We are at 666 Grand Ave, Suite 2000 in downtown Des Moines here. It's kind of odd for me to be standing on this side of the room because until very recently I actually worked in the city's legal department, so this is a new thing for me. So as we already talked through, today we're just appealing the administrative decision that misclassified my client's facility as a junk or salvage yard. We're not asking for a variance or arguing past requests for site plans. We believe my client's current use clearly fits with the property's grandfathered light industrial zoning and the existing certificate of occupancy, which allows for warehouse and office space. This site is legally grandfathered into the light industrial use under the city zoning regulations. There hasn't been any change of use. There hasn't been any expansion exceeding 50% of the value or size. So there's been no zoning triggers into that NX1 zoning classification. The property continues to operate as it historically has, as a warehouse with an office space. The city provided you all with a copy of our certificate of occupancy for this explicit use. We also have some photos of the warehouse area where you can clearly see it is not a salvage yard. Just kind of. Thomas Beck 1 is a designated transporter of medical waste under the Iowa Code. Yeah, it might be too big for that. I should have thought of new school technology and brought in a flash drive rather than bringing this in. You want to do it?
You want to help me? I can.
Thank you.
All right. this is kind of a first. This is it's like the price is right here. Yeah, yeah.
No, oh, there's a little ledge right here we could place it on.
So Ms. Moreno, I do have one question. I wouldn't
please.
normally interrupt, but with, these photos and graphics, and you're kind of showing us all this stuff, was this provided to the zoning enforcement officer at the time of their review and determination, or is this, in essence, you're providing us new information today that they didn't have?
They've had these photos since last week, but I believe they've also been offered to view the site in person, and all this is photos of the
Okay.
site.
Okay. Okay. I need a little help here because, as I said, we're not here to determine if we're interested in approving a conditional use. We're interested in reviewing the decision that the zoning enforcement officer made at the time they made their decision
Okay.
with the facts that were available.
We're just showing photos of the site as it is, as the zoning officer had the option to come.
Then I'm
view
going to
the
need
property.
clarification from my attorney if it's appropriate to bring, in essence, new information or, quote, current observations into this equation. We're supposed to be reviewing what did they see at the time they made their determination.
Yeah, absolutely.
Gary, I may not be very clear in how I'm stating my concern or
No,
question here.
that
but-
makes sense.
Yeah.
Am I running my time? Should I continue?
Well, I'll pause
Goulart
for a
decides?
moment on your time. I'm not going to take that away from you.
Okay,
It'll be like penalty time in soccer.
Right.
thank you.
Just never know when it's starting over.
So as I mentioned earlier, the record on appeal, and this is under our ordinance, or Chapter 134, 6.9.5, the zoning enforcement officer has transmitted the record, has transmitted to the board all papers constituting the record in this case. This appeal is based on the information that was available to the zoning enforcement officer at the time, at or before the time he made his decision. I understand council's position that this was available to the zoning enforcement officer, but I believe when I was looking through the documents that were provided earlier, that there was a request from the city to the appellant for any material to substantiate this use, and so the appellant had the opportunity to present that evidence at that time. The board can make its own decision about whether to consider this or not. But, in my opinion, because it wasn't part of what was presented to the zoning enforcement officer, it's not proper to consider in this appeal. But the board can make its own determination.
If the board members have any input here, just briefly, again, I don't want to slow down your presentation,
That's all right.
but I just kind of want to encourage, the weight of the issue here is how did they make their decision at the time with what they were available? And with the time you have, the better you can show us, well, this was our understanding at the time. This is what we were told at the time, especially if it would be different than what they're saying now. So I just encourage you to, if you're going to give it your best shot here.
Yeah, absolutely.
Yeah.
You guys can disregard the photos. I will continue on my presentation,
Okay.
and
All
you
right.
guys can consider my verbal words.
Great. Since Monica does a great job of timing, we'll put the ball back on the court.
Great.
All right, go ahead.
So Thomas Beck, one, is a designated transporter of medical waste under the Iowa Code and Iowa DNR regulations. Those are very strict regulations. The company collects packaged waste for medical offices, veterinary clinics, other medical offices. Examples of this are sealed, sharp containers, gloves, gauze, linens, and those are all already packaged. There are no hazardous or Category A infectious waste being handled by my client. The trucks delivered the sealed DOT-compliant containers directly to the building. The containers are placed into a secured staged trailer, and materials are shipped out within 3 days to South Dakota. And that is where they are processed. At no point is the waste unpackaged, opened, treated, processed, sold, or repurposed. All materials are stored indoors, fully contained, and out of public view. We meet the definition of a warehouse, which is a completely enclosed building that is engaged in long or short-term storage, in this case, very short-term. The turnaround is less than 3 days. And we don't meet the definition of a self-service storage or trucking and transportation terminal. This language is coming straight from the Des Moines City Code. A transportation terminal is typically a terminal that has trucks for hire that move goods. My client doesn't do that, and my client is also not a self-service storage facility. Here we are moving materials that are completely packaged from one space to another. We're not salvaging or processing them at this site. My client also is able to keep the medical waste into an area that is less than 200 square feet or more, or less. Sorry, that was a typo on my part. So it's less than a 200 square feet area where this medical waste is. That automatically disqualifies it from being described as a junk or salvage yard under the city's code. The property is not a junkyard or a salvage yard. There's no outdoor waste, no dismantling or resale, no visible materials or inoperable vehicles, and there's no environmental nuisances such as odor, dust, noise, or smoke. It is not heavy industrial use. Our certificate of occupancy allows for warehouse and office space use. Our operations are compliant with the Iowa DNR and the EPA standards, which require it to be taken into the building and transferred onto a truck to be shipped out. While the area is now zoned as NX1, which is a mixed-use transitional zone, the immediate surroundings, aside from a few new townhomes, remain predominantly light industrial in character and use. The new townhomes down the road are struggling to sell, and it appears to us that the city is increasing scrutiny on longstanding industrial properties like Thomas Beck 1 and neighboring businesses to make the area more attractive to prospective developers. It's unfair and problematic to selectively reclassify operating businesses to align with speculative residential development. Zoning should reflect actual land use and longstanding operational facts, not marketing concerns with the Grays Lake area. Thomas Beck 1 operates a clean, enclosed, compliant warehouse. Our use is consistent with light industrial classification. We respectfully request that the board overturn the administrative decision and affirm our existing legal use of property, which is as a warehouse and office space. Thank you.
I just got a couple of points to add real quick here. So I'm Alex Benskin.
Okay, I was going to ask, you're
Yeah.
certainly not Thomas Beck.
No.
I've always wanted to meet him, but I didn't think that would be possible.
I think he's somewhere else, you know. So I own the company, Thomas Beck 1 LLC, as well as the shredder MedShred, and we provide secure shredding and medical waste disposal to clients across the state of Iowa and beyond.
Okay.
We have a number of customers, just like the city of Des Moines, Polk County, state of Iowa, University of Iowa. I mean, you name it, we have a lot of customers that we provide these services for. So I think it's really important that we distinguish the fact that these services are typically done at the client's facility, so we use secure on-site document destruction vehicles to provide these services for the paper shredding side, and then we actually bring that material to a processor here in town, ABC Metals and Recycling, where he does process that waste, or it's not waste, it's recycled paper, into bales, and then it's resold to be used for new paper products. On the medical waste side, what we're doing is we're just going around to our customers, our clients that are pre-packaging this waste in DOT compliant, packaging group 2, sealed, leak-proof containers, spill-proof containers, where we bring them into our facility. We have to bring them into the facility because it's kind of, rules and regulations in the state of Iowa for medical waste are very goofy between state law, DNR, and what are we actually doing? And so we're doing our best to abide by everybody's laws that have all been repealed over the last 10 years. That's just kind of what it is. And so there's nobody that can actually tell us how we are supposed to do this stuff because nobody's got authority. The DNR doesn't, state law doesn't, we're just doing our best. So anyways, what we do is we're bringing that stuff in, and in light of trying to abide by what these rules used to be, it's like, hey, you can't transfer truck to truck. So we bring it in the facility, and we can contain that within 200 square feet before it goes into the other trailer to not be the junkyard classification. But our argument is that we're not a junkyard because we're not a processor. At no point, as you can see by the pictures that you can ignore or not, but there's not a processing machine that's in there that's breaking this stuff down. We have to hire another company out of the state to do that. What the reason for our pre-app meeting back in October was, as you may be familiar with the site, it's really weird the way the lot lines are all drawn out. And what I wanted to do was consolidate the lot lines and move the brown building that was at 1200 Thomas Beck next to the building at 1000 Thomas Beck and buy a processor and expand that and then open up that 9 acres to sell to a developer that could go and build something, because that is not me. I am not a developer. So that was the reason that we went in there, and then it's like, hey, well, you're processing medical waste, and it's like, well, we're not. We're like warehousing it to send it off to the guy that does process it, and so we just want to be able to continue to do what we're doing there by appealing this decision to say, hey, we're trying our best to abide by the state laws that really don't exist, and then as we continue to grow and we really need a processor to really process this waste, which, talking with Sue Johnson at the Iowa DNR, I think somebody's maybe familiar with her, she gave us the green light for how to go about doing this, and Metro Waste Authority says, hey, here's how you go about doing this, and then we can go buy a machine. And in talking about that, it's like, hey, you can't do that at this site. Well, we're not seeking a variance at 1000 Thomas Beck to put a medical waste processor in. We are going to do that somewhere where we already have heavy industrial zoning that's going to allow it. We have our spot picked out where we're going to do it, and when the time is right, we want to do that. And I really wanted to sell the ground to have the money to buy the processor. So it's like, wow, how do we get past this without costing me extra money hiring lawyers and fighting everybody back and forth? I just want to do what we're doing here as we've been doing, which I don't think is processing. Sorry. And Chris says in his presentation that it's not processing. He said it's not processing. Like, if we replay the tape, he said it's not processing. So we're not processing.
Okay. Questions?
It's complicated.
Cuckoo, go ahead.
Is there a similar use case in the city? Do you have a competitor in the city of Des Moines?
Yeah, you bet we do. Daniels, and they operate off Park Avenue in an office complex.
Okay.
And Clean Earth operates behind the airport in not heavy industrial.
So do you have any indication of what their zoning classification is?
Office.
Okay. Thank you.
They're off Park Avenue they're an office building. Clean Earth is up by the airport. They're not heavy industrial.
Other questions?
Stericycle used to have a facility right down the street here, and that wasn't heavy industrial.
Okay, you got a lot going on here. You're a quick talker.
Sorry.
And no, I'm not saying you have to apologize for that, but again, I want to keep our focus simply where this board's focus is. We aren't here to want to stop a business. We aren't here to encourage a business. We aren't here to see if the state of Iowa does or doesn't need to give you a permit. We're just here to see if the zoning enforcement officer, in carrying out the city ordinance of Des Moines, was interpreting the ordinance correctly. So a couple of questions I have. So yeah, you got this cool business, you're doing this stuff, you want to develop this, and you want to build here and do that. Generally, did you just move in one day? Did you buy it first and then start this? Just very quickly, when did you either acquire or start here?
I'll try very
Okay.
to make this very quick. I started the business in 2010, and we started doing paper shredding.
There.
We started on Southwest 6th Street.
Okay, I'm asking about this.
Okay, we moved in 2015,
He purchased it from his father.
in 2019, 18.
I just heard 2015, now I'm hearing.
Well, that's when I moved in. I leased it.
Okay.
Leased it in 2015, and then bought it from him in 2018 or 19.
Okay.
Maybe we went under contract in 18.
And did you
close in-
start this type of business at that time?
We were doing the medical waste since 2014, 2015.
Okay. And again, in looking at the city ordinance, certainly a title to a book, a title to a chapter, well, it's important. Moby Dick, what's this about? So the title is junk or salvage yard, but the description says a building, if I break it down and pull it out, a building where waste is stored or exchanged or handled for disposal.
In an area that is more than 200 square feet.
Okay, so on purpose, you knew it wasn't even 200 square feet? You had a little tape on the floor and you showed that to the zoning enforcement officer?
The zoning enforcement officer had all of this information about the
Okay.
building.
So when you came to the pre-app meeting in October of 2024 and the city staff said, hey, these uses aren't allowed, maybe not even knowing what you were doing, was there any reply at that time that, oh, well, wait a minute, we're sitting here at the pre-app, we've been doing this since 2019?
Well, we did tell them we've been doing it for a very long time, but this was all a surprise. So in the meeting, I wasn't exactly well-versed with all the particulars of the city code and 200 square feet. I think it just comes down to the fact that we're not processing this particular waste.
But it's still a building where, and I'll come back to Ms. Moreno's comment here, but it's still a building where waste is being exchanged and stored, correct?
Well, it's infectious material, but it's not considered waste until it's been processed according to state law.
Well, we're here to look at city code. If I put waste in a garbage sack at home, and somebody comes and picks it up, and they just store it somewhere else, they would need to meet our city requirements for junk and salvage yard and handling and management of waste. So that's what I'm trying to figure out here. You're handling people's waste material, correct?
Effectively, yes.
Okay, that's a fundamental here. Now, if we determine that the board is correct here in their decision, I may ask them a question here in a moment, and you limit what you're doing on this waste management to meet these other requirements, then is it your contention, well, we should be allowed to continue to do this if it's a very tiny part of what we do here?
It's my contention that this is absolutely not a junkyard or a salvage yard.
But junk or salvage yard is just the title of the chapter. It's the description of what goes on that's the meat in the sandwich.
Yes.
A building where waste is stored or exchanged or otherwise handled for reclamation, disposal, or other similar purposes.
It's staged on a trailer.
I understand what you're telling me, but
It's in an area that is less than 200 square feet.
Well, I think
Yeah.
we can do it outside if you're not going to be upset as the DNR guy that we're doing it outside.
I don't understand your statement.
Well, like as the DNR says, we've got to bring it into a building, we can't do truck-to-truck transfer.
Well, this isn't a DNR hearing.
Sorry.
Gary, did you have something you wanted to ask or assist the board with?
I wanted to talk about the definition of junk or scrapyard or salvage yard, since that's obviously a point of contention here. The ordinance has to be read in its entirety, and when we read the ordinance in its entirety, the sentence begins with a building or open area, and then it then has some qualifications, as the chair has read, where waste, et cetera. And then it says, and then it says encompassing. So the encompassing, the verb goes with a building or open area. So the area is not just an area inside, it's a building or an open area encompassing an area of 200 square feet or more.
I understand that. Thank you. Okay, any other questions for the appellants? Okay, appreciate your patience with me. Thank you. Appreciate your presentation. I do need to remind you here, okay, do we have speakers in support of the city's enforcement action? So I think this would be the civilians at large. Is there anybody here that supports the city's enforcement action, meaning their statement, what they believe? Are there any speakers aside from the appellant that are in opposition to what the city has stated. Anybody, it has to be related to the case, but any neutral comments related to the situation at hand with the facility, its interpretation of the zoning ordinance. I don't know that you can. Unless you have something you wish to share, you need to come up, and it needs to be germane to this case, and you'll need to sign in with your name and address. Then you have up to 5 minutes.
I'm just going to, Matt, Cambridge, Iowa, that's where I live. So I take my waste to Goodwill and to the Salvation Army, and they store it and resell it. How is what they're doing different from that?
Okay,
That's it. That's all I got.
all right. Thank you for coming. Appreciate your comments. Anybody else that wish to speak in neutrality? Seeing none. Do we have questions for the zoning enforcement officer or the city staff? We have questions for Chris? Anybody? All right, if there are no, yeah, go ahead, Cuckoo.
So, Chris, has the company always been in violation of the zoning ordinance as far as medical waste transportation, processing is concerned?
Yes, I think I understand the nature of your question, and yes, and under M1, we would have constituted that as a violation, and under the current code, it would be a violation.
So, as far as the notice is concerned, it was triggered by the review. Okay,
It was.
thank you.
Okay. All right. Well, Chris, you have let's see, you've got a rebuttal. We're going to have 2 rebuttals. Again, this is a unique one. I appreciate the audience's patience here. I know we have some other items to get to. So, Chris, we'll give you some closing statements, rebuttal here.
Okay, first off, in the city of Des Moines and under the code, the comprehensive plan is important and adds value when we determine where uses are located here. We have received a letter from Grays Lake Neighborhood Association in opposition of this. The other thing to consider as you make a decision on the determination is they're wanting to expand. So the potential to expand this use may become more intense than it is. And I would also just like to reiterate what Gary had mentioned here to the board, that it's under the roof. The code for junk and salvage does say building or open area. You could surpass that with square footage in a truck. You could surpass it inside. So it certainly meets that definition under the old code of 3.6.4, where it says a building or open area where waste or scrap, used or secondhand materials are bought, sold, or exchanged. And maybe a good way to look at the difference between a warehouse and a scrap yard here would be something similar to our plain definition of a warehouse is a building or structure to be used for storing goods and materials before being sold or distributed. Think of that like Atlantic Bottling, where you'd back up a big truck full of Coke bottles, and then a bunch of smaller trucks would come in and process or move those and distribute them out to a retail store. That's much different than the model that we've heard today from Mr. Benskin, adding additional rationale and I think justification in upholding. I respectfully ask that you uphold our determination of a junk and salvage yard. The other thing is we aren't really here to argue about state regulations and DNR regulations. Those are 2 separate things. I'm sure they're operating just fine within those guidelines. We couldn't offer any direction or advice as far as that goes. Again, we don't allow business owners to designate their use. That has to come through a formal process, and that didn't happen. Upon review, this would have gone much differently from the approval in 2010 to the medical waste recycling being moved in 2014, we just heard. We would have required a conditional use, and it's very possible maybe they would exhaust a rezoning for this parcel, which would be heard by our P&Z. With that, I would respectfully ask that you uphold our determination.
Yeah. Chris, I do have one question, and I asked this as well for the benefit of the appellant also here. They had stated, yeah, that this use had been here for a long time. But even under the, quote, old zoning ordinance, which, that was in place a little over 5 years ago now?
That's correct.
Okay. Even under the old zoning ordinance, with what I just heard you say, they would have had to, before starting that use, even in an M1 industrial, come to the city and say, hey, we do want to handle some waste here. Industrial, I think, machinery, cement making, there's hundreds of uses, but even in a light industrial or industrial, waste processing handling still needs some special handling, if you will, pun intended, correct, for
Yes,
permissions?
absolutely. And that would,
And to your knowledge, none of that happened?
no, that would have come with a rezoning. As mentioned in the pre-app notes back in 2010, that we've shared with you folks, there would need to be a rezoning to M2 with a conditional use granted by this board. And under the current code, it would need to be rezoned to I2 and obtain that same permission.
Okay. All right, thank you. Okay, the property owner or business operator, you get the final 3 minutes, so closing is yours.
Thank you, I appreciate that. So we also were provided with the community objection from the Grace Lake Neighborhood Association. It seems that this objection to the medical waste was just purely based off of the agenda without any of the actual information. We've presented our process of how this company operates, and as you can see, these concerns aren't really valid. We're not going to be impacting wildlife in any parks nearby. It's not going to impact there's no nuisances created by this. There's no impact to residential areas nearby. So I just wanted to point that out in case you all had not had an opportunity to read Ms. Ortale's objection. I also, and I know that you guys are not in my service, but it's my understanding that we're under the 90s code, so not even the one that was retired 5 years ago. We are authorized under the code that was in the 90s, and I probably should have printed off. I went to the Drake Library and had reviewed that, and I agree that heavy industrial use, if classified as that, is not the M1 zoning that it was prior to this, the rezoning of the area. I'm not confident that the junk and salvage yard definition in the 90s would prohibit, I'm not confident that the business would fall under the junk and salvage yard definition from the 90s code that we are grandfathered into.
So, quick question. So, is your argument that the zoning officer erred in the determination because you should have been grandfathered into it already?
Yes,
That's the argument.
and that it is not a junkyard. That we are grandfathered in. Our argument is that it is not a junkyard or salvage yard under the grandfathered in zoning.
Okay, whether it seems like it or not, I think the goal of all of us here at this board is to tell everybody, big picture, city as a whole, carry out our ordinance, have a nice town, have businesses be successful. But I'd asked our board attorney a question here, and I really need to understand, since you had mentioned it, well, not under this current ordinance where junk and salvage yards are defined, but the old one, the way it was defined.
I don't think we fall under a junk or salvage
Okay.
under either code.
I need to see that from someone. You can state you don't think that you fall under that, but I need to see that code language. So I don't know, Gary, can I ask, is that something the city can look up right now?
No, it's only available at the Drake Law
Okay.
Library.
It's actually not only available at the Drake
Okay.
Law Library.
Oh, you have it.
I do. And so, first of all, I want to respond to council's comment regarding the definition of junk or salvage yard. The junk and salvage yard definition was from the current code, as was the warehouse definition that council used in their presentation, which is
Yes.
why we were looking at the current use. In order to determine whether this use was lawfully established under the old code, there are some requirements here, even if their position is that this was a warehousing use. Under the former code, section 134-1087, 3, which permits warehousing or similar use in one light industrial district, it requires that the owner or occupant has provided the community development department with a written statement upon a form acceptable to the community development director, which describes the use to occur upon the property and the nature of any odors, gases, noise, vibration, and other environmental impacts that may be generated by such use, and which certifies that the use upon the property will be operated in a manner that does not permit any odors, gases, noise, vibration, pollution of air, water, or soil, or lighting to be emitted onto any adjoining property so as to create a nuisance. And then subsection E says that the use shall be operated in strict conformance with the statement provided pursuant to paragraph D above. I don't know that there is any evidence in the record that that statement was provided and that the use was operated in accordance with it, which would be required for this board to find that there was a prior lawful use.
Okay. And I don't want to get into big trivia, but our past zoning ordinance, I think its fundamental guts went back to 1968, if I'm correct. 65. See, Bert's helping me out. Yeah, so the quote 1990s ordinance, most of that had still been in place here very, very recently. It's never a lot of fun to redo an entire zoning ordinance.
Yeah. And a question on
Yes,
that.
Cooper.
So as far as the expectation of being grandfathered in at 2015, based off of Des Moines ordinance then, how would you classify the operation?
I believe, and I still believe under the new zoning, that it is a warehouse in an office space.
Okay. So should that have been established when the business started in 2015?
In 1998, when the certificate of occupancy was issued, it was for a warehouse and office space. I don't believe that you need to change the certificate of occupancy if the use is remaining the same, but I could be standard to be corrected.
Okay. Yeah, this is going to get down to a lot of what one side or another might believe is some interpretation. To me, a warehouse or office space would be for goods and services that aren't related to disposing of trash, garbage, and gory medical waste, even if we really want to get into it. They're totally different things. Gary, is there something you want to add?
A couple of things. Can we just get any clarification? Was the statement that I just referred to from the prior code, was that statement provided to when that use was going on?
Well, I mean, we didn't know we had to do that because that code had been retired.
Yeah, so the 90s code, I believe, had been retired. I think there was a new code in the early 2000s.
So just for the board's edification, the code was recodified in the year 2000. That was for legal compliance purposes. I don't know that there were substantive changes made, and my understanding is that the requirements that I read to the board, and I think that are shown up here, were still in effect until the Chapter 134 was repealed and replaced in 2019. So my question was whether that the statement that's referenced in Part 3D was provided to the Community Development Department.
Yeah, no, see, we had hired a guy named Ed Kiker to do some other stuff, and I had called him and was like, can you make sure we're good to do this here? And he had called somebody at the city, and the city was like, yeah, you're good to do this based off of how we described the business at that time. But he's since passed away, and I don't know who he called, and so I can't call him. And now it's even more complicated.
Right.
Because,
So as far as you know, that was not provided.
No.
And then the other part that I would like to address, because the definition of junk and junkyard was, under that code was raised. Do we have that to pull up? The junkyard definition is pretty similar to what we have now. Means any place not fully enclosed in a building, excluding a salvage yard, which is used in whole or in part for the storage or deposit of junk, encompassing either an area of 200 square feet or more, or two or more inoperable vehicles, motor vehicles. That's similar to what we have now. And then junk means all old. There's a long definition of junk that I don't think I need to get into, because it seems their position is that they were lawfully established as a warehouse.
Okay. All right, well, you've had your rebuttal. I think it's time for us to close public portion of the hearing unless the board has any final question for the applicant themselves to give them some credit here. Tom? Okay, well, we're about to go into board deliberation. Do I need to give us a 5-minute break here? Okay. All right.
Thank you all so much. We'll sit
Thank
down.
you, thank you. All right, we're going to close the public portion now and go to board deliberation. For the board, our attorney is part of the board's deliberation, staff or the audience are not. So we've had a lot of information presented here. We've had a lot of descriptions and statements presented, but again, I want to remind my colleagues, we're just here to determine, do we believe that the zoning enforcement officer, in carrying out their authority with the information that they had presented to them and had available to them, including the city's own record, did they make the correct decision? We're not here to decide if we like what they're doing or, well, gee, we give them a special permit if they come back next month. Maybe we would. Maybe they can get a rezoning. But that's not our decision today. It's just basically, did the city make the correct decision based on the ordinance, their observations, and the information at hand? That's the best way I can describe it. So, what do you guys think about that?
I have a question for Gary. Gary, as far as use is concerned, what's the thought process for something being grandfathered in?
I'm understanding this as more as kind of a philosophical question, as opposed to, anything that the city might have had in mind when adopting its current code and the grandfathering uses. I can't answer that. I don't know. From a philosophical perspective, I think, and this is guidelock on land use, so take it for what it's worth. I'm not researching anything. I can certainly do that if you'd like me to. My understanding is that the grandfathering a lawfully established use is so that there's no ex post facto laws, so that you can't come in after something has happened and then make it retroactively illegal. You see it a lot of times in a lot of different statutes and ordinances where, if it becomes illegal to write with my left hand tomorrow, I can't get punished for writing with my left hand for the rest of my life. I think it comes from that. And so you're looking at if somebody's acting in a way that's lawful at the time the law changes, then in many or most cases, they're not that behavior or activity doesn't become illegal just because the law changed. unless and until something else triggers compliance with the new law, which for our purposes is usually, site plan, rezoning, different triggers like that. So, I think there's questions about the specific use that's happening, that sort of thing, whether that's continuing or if it's changed.
And just a follow-up question on that. So is there a fundamental difference, and I'm thinking through, let's say, an alcohol license, right? If there's a bar in a location and there's a change of ownership, change of lease in the location, it's not transferred. Does a change in use trigger some kind of review, or does a change in use make it so that a use case that's being discussed is no longer grandfathered in?
There are definitely times where a use may be discontinued or it might be changed significantly enough that it requires, it triggers compliance with the new ordinance. Enlarging, you can't enlarge a non-conforming use, that sort of thing. Zoning regulations are typically governing the use of the land as opposed to something that regulates the people. So the parties can change, but the zoning doesn't change unless, the zoning doesn't automatically change just by virtue of a change of ownership or a change of a lessee or something like that. I'm afraid I didn't answer your question, but I'm doing my best. So,
You're in the neighborhood.
Yep.
okay, I'll take it.
And Cuckoo, that is a good fundamental on everything. As an example, gas stations or car lots, you could have concrete lot line to lot line back in the 60s. No one cared. No stormwater, no nice plants in front. And we still have some sites that way today that were built in the 60s. But 25 years ago, when they updated some of the zoning ordinances, there's a requirement for setbacks, some green space, some landscaping. So if the use stayed and never shut down, never discontinued, it got grandfathered in. But there does come a point in time, if the use discontinues, it's time to kind of bring it up to the current standard that everybody else is now meeting. And that's, to me, that's the whole thing with grandfathering. It used to be you could build a house and you didn't have to have a tree in the front of your backyard.
Yep.
Now, if a developer builds a house, the zoning code says you have to have a certain amount of trees and landscaping.
Yeah.
There's a reason for that.
And part of my questions are just thinking about when the transaction happened, right? So if it was a truly separate transaction where it's an independent party selling to an independent party, wouldn't the current zoning laws apply?
For the most part, yes. I can't say absolutely yes because I'm a lawyer, and we can't ever say always yes or no. For the most part, that's right.
And I might add to it, like when we give a conditional use for a bar, and again, I don't want to get off the subject too far, it's not about the operator of the bar, the owner of the bar, it's the use. So if the use would discontinue or the use changes, it could get sold 100 times, but as long as the use is similar or does not discontinue, then it carries along under the zoning ordinance if it was a legal use at the time. But once that expires, again, that grandfathering, that's a way to get things caught up. But I think from what I've heard today, that even if we want to look at the old zoning ordinance, there would have been a requirement, there would have been a stop to pause and go, hey, now what is it you want to do here? Even under the old ordinance, under an definition of certain industrial activities that this was zoned, operations or businesses related to handling and management of waste would have had to have additional review, special conditional uses. In other words, this could have been vetted then and reviewed. Maybe it would have been approved, maybe it wouldn't, but we've still arrived here today. It doesn't meet the requirement in the code. That's what the city has laid out for us, and I think they've stated it as clear as they can. I think the definition is very clear. And by the way, a Goodwill or a Salvation Army, that's not garbage. Those are used goods. I bought nice pairs of shoes there before, so I'm not going to spend any time further on that, but trash, garbage, waste material, none of this stuff is going to be, a medical waste rag isn't going to get sold at a store for somebody to use in crafting. It's going to get disposed of because it's infectious. So to me, this is a case about waste material that's being exchanged, stored, transferred in a building that does not meet the code requirement. That's what the city noticed them on. They've continued to have the use. We're not here to determine any penalties, next phase, next direction, just did they make the decision correct? In my opinion, I believe they've had, and I want to make a motion to uphold the zoning officer's determination in this case and deny the requested appeal of the administrative decision. All right, so we've got a second. Let's go ahead and take a vote on that. We've got a motion and a second. All those in favor to deny the requested appeal of the administrative decision, raise your right hand. 1, 2, 3, 4, 5, 6, 7. Okay. All right, so it's not up to us what your next step is, but I hope there can be some resolutions here. We should have plenty of places in this fine city where these businesses can locate so he can continue to be successful. All right, that concludes that first item on the agenda. But these are important things, so we spend some time on them as needed. Okay, so we're going to move on to item 6, amendment to a conditional use at 102 3rd Street by Coppola Enterprises.
All right. Board member, or chair, members of the board, my name is Bert Drost, planning staff of the city of Des Moines. Item number 6 is a request to amend an existing conditional use that's in effect for the property at 102 3rd Street. I believe some of you might be familiar with this. It's the Tipsy Crow business that's been in operation there for several years. It's located on the east side of 3rd Street, just to the south of the Court Avenue Entertainment District. Just to give you some history on this, the business originally opened up as a restaurant, and at some point it was determined they weren't meeting the threshold for being a restaurant, so they applied to the board and were granted a conditional use for a tavern, originally back on July 25 of 2019. At that time, they just had some general conditions, one of those being that they shall comply with Article 9 of Chapter 42 of the City Code pertaining to noise control. Within their first year of operations, the zoning officer had determined that they were violating that condition as they were having events without the necessary sound permits. So the zoning officer brought that conditional use back to this board for reconsideration. And then on October 23 of 2019, the board held a hearing on the matter, and at which time they did find that the business was in violation of the conditional use, so the board amended the conditional use as follows. So what's up on the screen is the decision and order that's been for this bar since October of 2019. I would just point out that right now, condition number 3 says any live outdoor music or performances is prohibited, and then condition 4 says any outdoor sound or music on the patio must be at levels considered to be background auditory in nature in accordance with the Class E sound permit. And so you might see on comment cards, there are a couple people that allege they've violated that. The zoning officer is here, he can speak today, but when I asked him this morning, he said there haven't been any complaints brought to his attention. There's one police report within the last 6 months that I can show you later, but that was found to be non-substantiated. But again, this is the conditional use that is in effect today. They're now wanting to amend the conditional use so that they can have up to 2 events each month or each week on the outdoor patio. According to their application, they want to have those events on Friday evenings from 4 to 7, and then on Saturdays, 2 Saturdays a month, they would have events from 12 to 5, and then the other 2 Saturdays, they would have events from 12 to 9 p.m. And again, that's the request. In a little bit, I'll get to our recommendation, which really clamps down on that a little bit for consistency purposes. But here's the sketch provided by the applicant. This just shows the business. You can see it's the old train depot. The bar is operating within a portion of the building. And then they have this large 6,000 square foot patio that kind of wraps around the east and south and a little bit to the north of the building. And then this is their sketch. Again, this box down here at the bottom is the building, and then they're showing a stage that would be just to the south of the building. Here are some photos. Again, this is from 3rd Street. This is zoomed in. And then this is kind of looking southwest across the site. The stage is back here in this area. And they have an outdoor bar. Again, the stage is kind of behind the bar. And so, as I mentioned, they're wanting to have up to 2 events each week outdoors, again on Fridays from 4 to 7 p.m., and then on Saturdays either from noon to 5 p.m. or noon to 9 p.m. Our recommendation, we do believe it would be okay to allow some outdoor sound. However, given the history of this property and just the number of residential uses that are in close proximity, I don't know if you noticed on the map here, there are Metro lofts and the Confluence lofts immediately to the east, and then there's also the 119 4th Street and a lot of condos and residential uses immediately to the north, and then also above the Hy-Vee on Court Avenue, so and the Rumley lofts here to the southwest. So there are quite a few residential uses in close proximity. So our recommendation, again, is that they have some ability to have outdoor sound, but we recommend that it be limited to from 12 to 5 p.m. on Saturdays only. They wanted, 4 to 7 Fridays, noon to 5, or 5 to noon to 9 on Saturdays. We just feel that just for everybody's sake, having some predictable, consistent hours would be really to the business's benefit as well as neighbors. If they limited those events to either or to only on Saturdays from noon to 5 p.m., that would, everybody would come to expect that from May 1st to November 1st each year. On Saturday afternoons, there could be loud music or amplified sound on the patio. So again, our recommendation is just to revise 3 of the conditions. On the screen here, the strikeouts and then or what would be removed, and then the underlining is what would be added. So for condition number 3, where it says live outdoor music or performances is prohibited, we recommend that be changed to live outdoor music or performances shall only occur on Saturdays between May 1st and November 1st between 12 p.m. noon and 5 p.m. and it must be in accordance with any necessary sound permit from the issued by the city. And then on condition 4, we would amend it to add outdoor sound or music other than on Saturdays between May 1 and November 1 between noon and 5 p.m. Shall be limited to levels considered background, auditory, and nature. And then condition number 7 is a condition we used to put on all of these. It had to do with loitering. We've been removing the requirement prohibiting loitering just because it is hard for police or for anybody to enforce on loitering. But those are really the changes we've recommended. We did get 7 comment cards 7 cards back. 2 are in support, 5 are in opposition. You only see 4 because the one doesn't provide an address, so we're not sure who that is from. But these first 2 again are in support. And then there are 5 in opposition. And then these last 2 cards do kind of allude to the fact they've been having a lot of noise or loud music, which would be in violation of their existing conditional use. But as the zoning officer can testify, he's not received any complaints to that. that concludes my presentation. Are there any questions for me?
All right. Always informational and succinct. Appreciate that, Bert. But do we have any questions for Mr. Drost? Anyone? Cuckoo? Okay. Bert, I only have two. I'm going to keep it simple. It's not what I call unheard of to think that, well, gee, in the Court Avenue Entertainment District, there might be some live music once in a while here or there. Gosh, that's to be expected. Is there a boundary to that Court Avenue Entertainment District? Is this in it? Is it out of it?
There really isn't a defined boundary of the Court Avenue Entertainment District. It's more just a general area.
Right.
You can see it's about half a block to a block south of Court Avenue itself. And there are a number of bars that kind of, so I guess it's a full block south of Court Avenue, but there are bars kind of along 3rd and 4th Street.
Okay.
More-
And
more
related
3rd.
to that, well, certainly this building has been here a long time. It was one of the old depot buildings for the Rock Island, amongst a whole bunch of them there, I think. This was not a bar until 2018, correct?
Correct.
You're really good at trivia and dates, but to the best of your knowledge, the Rumley Lofts conversion, the Hy-Vee Apartments, the Vine Street Lofts, all that, were those there prior to 2018?
The Rumley Lofts was one of the first residential. It was a conversion of a warehouse, and that was before 2018. It was probably, I would say, before 2010. And then the Metro Lofts and Confluence, they've really been in the last probably 10 years ago.
Okay.
And then
So we've had some established residential in this area before we had
Right.
a bar that at one time was permitted to have some outdoor music, but apparently, and again, we do conditional use based on the use, not who operates it, but there were some problems with that,
correct.
and that's why I'd been taking it away.
Right.
But in essence, for the last 6 years, they've been operating as a bar without any live music, to the best of your knowledge.
Correct.
Correct? Okay. So this is just a request now to bring back the live music.
Right.
Okay. And I understand their request is a little different than what staff rec is for ours, correct?
Correct.
Okay. All right. Anyone else for Bert? Okay. Thank you, sir. All right. Applicant or representative of the applicant, thank you for your patience in waiting today.
No, thank you, guys.
Just as a reminder, we need your full name, address, and just do the sign-in sheet when you have time.
Yes, my name's Chad Cook from 102 3rd Street, the place this gentleman was speaking about. Thank you for letting me speak. I'm just here for that conditional use from 2018. I have talked with Frank Dunyoung for quite some time, and my hours are pretty much a Saturday, 12 to 5. Maybe if I could, maybe do a 4 to 6 or something once or twice in a year for the summer, that would be nice. Typically, though, I'm just looking for 12 to 5 on Saturday afternoon after farmer's market. I mean, I love listening to what you're saying. I think, wasn't that place a bar for like 101, 515, for quite a few years before that? Like 30 years? Oh, was it? That's right. Was it? Well, I got to tell you, I have a great menu if you'd like to stop by. I have a new kitchen, lots of food, and so we do other things than just the music. But yes, as far as I've talked to the neighborhood association, a few of them showed up. I told them the plan. Seemed like the few that I talked to seemed like it was okay. And like I said, I'm not looking to go into the night. I'm just looking for the afternoon. Just kids and family come, and grandmas, grandpas, nieces, whatever, they like music. So I'm figuring if we could do something during Saturday afternoon, that I'd be happy with that. So, gosh, really, I don't have a lot to say here. I'm trying to appease, with the neighborhood. If they have a problem, they can come and talk to me. I will keep the decimals at a certain rate. I'll be there the whole time when the band's playing. Yeah. I just wish you reconsider the issue, that's all.
All right, we have questions for Chad. Just a couple very brief ones, Chad. Now, have you been operating yourself here as, are you the owner of the bar, if not the property, or what's?
I'm the owner of the bar.
Okay.
It's been about November 18th of last year, or
Okay.
about a year and a half, I guess
Okay.
I'd say. Sandy Capola owns the property.
Mhm.
I have a good relationship with her. I ran the place for quite a few years, but I bought it, like I said, a year and a half ago. So I'm very familiar with it. And,
Right.
you know, I'm around the community a lot. I live downtown, so I'm always there to help.
So staff is kind of pretty close to what you just mentioned, right? You want to have music in the afternoons?
Afternoon, yeah.
Okay, and that's kind of what staff has here as a recommendation.
Yep, and I like the recommendation. And
Okay.
actually, I'll take baby steps, work
Yep.
on it. If we can work on something, go from there.
And if we were inclined to approve that and that works,
That-
then maybe we've got
I would,
the happy medium everybody's after?
I wouldn't complain, that's for
Okay.
sure.
Okay.
It'd be nice for an
All right.
afternoon. That's what I'm looking for.
All right, good enough for the moment. Thank you, Chad. We'll check back with you in a
Thank
few
you.
minutes. Is there anybody that wants to speak in support of the applicant's request? They get first shot. Seeing none, anybody to speak in opposition to the applicant's request? Come on down. Need your name, address. Appreciate your patience in waiting.
Okay, thank you. I'm Kurt Simmons with the Science Center of Iowa, and we, this month of May, are celebrating our 20th anniversary here in downtown Des Moines. I'm here representing a very innovative staff and management team and a visionary board of directors, and we've had pretty lengthy and engaged conversations about this. We view ourselves as good neighbors. We try to be very supportive. In fact, we're very heavily involved with the Downtown Chamber, the Greater Des Moines Partnership. We think doing what's best for all is really important to the growth and vibrancy of downtown. In fact, about 8 years ago, we decided to close our cafe. A big consideration for that was that we felt we didn't need to run a cafe when there were such great restaurants in the neighborhood, and we have pushed our attendees to those neighborhoods. In fact, now have a partnership program with a good number of those restaurants so that our visitors get a discount there. So we're really trying to be a zone neighbor here and promote things. But I want to raise two concerns. One is the ongoing perception of, general perception of safety issues tied to Court Avenue, and the fact that this feels like it's beginning to encroach more closely on the Science Center and our family-oriented business, and spilling over directly next to our parking ramp, which we own, the parking ramp next door to the Tipsy Crow. We have seen pretty significant increases in vandalism and loitering over the last couple of years, to the point that we have had to hire nightly security rounds, and at some considerable expense. We have spent in the last year between $3,000 and $5,000 just replacing parking garage arms that are vandalized. And our staff has to go out every morning and sweep pretty considerable amounts of garbage that are left in the parking ramp, including human waste, that has to be cleaned up before those folks come to the farmer's market and expect a clean, healthy environment to be able to engage in that wonderful activity. So we have general concerns about that swelling of the entertainment, adult entertainment zone right next to our doorstep. The second concern I want to share is how we as a business have had to respond to some of the pressures and conditions of downtown. I mentioned the farmers market. We fully support the farmers market. We go out with our solar telescopes and let people look at the sun in completely new ways. We're trying to sneak science education into every activity. But the reality is, by our estimates, the farmers market reduces our attendance by 30 to 50% on any Saturday that they're open. That's just lost traffic for us. It's lost revenue. Again, we fully support the farmers market, and we are working around that. We also suffer attendance reductions anytime there's an event downtown. We think of downtown as a one-trick pony, if you will. If there's an event going on, many of our customers say, if I'm not going to the art festival, I'm not going downtown. And we see a reduction in our traffic on those days. Again, we are very supportive of those events, helping to create a vibrant, family-friendly downtown palette of offerings. Fully supportive of that. What it means to us is that we need to change our business model to be able to open up new markets at new times in new areas. We have significant amounts of evening programming, for example, that we've grown considerably. We piloted a new program this year with a music video kind of presentation in our planetarium. Started a year ago in May on Friday and Saturday nights, aimed at family audiences, essentially sold out to capacity Friday and Saturday nights for a year. We're going to renew that and expand that programming next year. We host private events. We typically host 3 to 4 proms every spring and into early summer. We have a lot of school events. We have education organizations that come into the facility, essentially rent the facility for the evening. And we have camp-ins with youth scouting groups and a program we call Almost Camp-ins, so that families show up around 5 o'clock and leave about 11 o'clock after having the run of the Science Center to themselves. So we're adjusting and growing our market offerings to meet these new available times that families have to engage with the Science Center. It's really successful. None of these are necessarily new programs. We've been doing them for 20 years. We are just having to amplify and grow those programs. We also serve some special audiences. We're really proud of a monthly program in the evenings we have called Century Friendly Hours. We open up the Science Center for free to any family who has a member on the autism spectrum. Very special audience. We've got to adjust the lighting, the sound, the buzzers and everything, reduce the auditory stimulus, visual and auditory stimulus in the whole of the Science Center, and it requires special training for staff to be able to engage that audience. We've had a number of families tell us this has become an essential part of their healthy family engagement to have
Kurt,
science.
I don't mean to be rude, but those that wish to comment for or against have 5 minutes.
Oh.
We're at 6.5. I might, just as a courtesy and out of respect for you, if you could kind of wrap up your remarks with any final high point.
That really gets to it. I mean, a big part of our weekend audience is on Saturday afternoons. I'm concerned that that sound is going to spill over directly into our open-air ramp and right into the entrance of the Science Center, and we've got some conflicting audiences there that hit right at that boundary.
Okay, I very much appreciate that, and certainly the board. Do we have any questions for Kurt? Okay. All right, thank you for coming down today to give your comments. Very much appreciate it. You're a great part of the downtown fabric here. All right, anybody else that wishes to speak in opposition to the applicant's request? Anybody wishes to speak in neutrality to the applicant's request? Hang on a second, we'll get back to you, Chad. Do we have any further questions for staff in relation to this request? Anybody? Okay, so anything you guys? Nope. Okay. All right, so Chad, you get to have the closing comments. You got up to 3 minutes.
Just a quick moment, and thank you for your input, because I like to hear that. I really do. I just like everyone to know, as far as, I'm there almost morning to morning every night. And, you know, we get a lot of families as well. So, I mean, in the afternoon on a Saturday, we got, like I said, grandkids, kids, they're having a good time. They're eating food, and they're hanging out in the sun, and we're family oriented. A little bit later at night, it does get a little younger crowd. But typically, I mean, we do have food. As far as the defecation and things in your thing, there's a lot of homeless people, and some live in there, and you know, thank goodness, I mean, I see everyone, but I think downtown is on the right track, is what I'm trying to say. And we can all work together. That's all I'm saying. So, that's
Okay.
it.
All right. Thank you, Chad. We'll close the public portion, go to board deliberation. Any thoughts from the members? Dave, you haven't said much today.
No, I think, what I think is pretty refreshing about this is we're trying to take a small step here, and we've got an owner that wants to understand what needs to be right, and he wants to prove that it can be right, and he's willing to take this on, and I think the city, in that same regard, is willing to entertain that, and this has certainly been kind of a controversial area for the last couple of years for us, so I'd be happy to go along with staff recommendation, and I'll hear everybody else's comments, but I'd be happy to make a motion on that if everybody else makes their comments.
Is that an official motion then, Dave, for staff rec?
Yeah, unless anybody else wants to make any comments, yes.
Yeah. Anyone else?
I think if we were going to take a chance, you know, having it be on Saturdays only, following the farmer's market, give it a try, see how it works out for the season, could be maybe cool with a new business owner.
Well, would you like to second that motion?
I'll second Dave's motion, yes.
Okay.
Thank you.
All right, so we got a motion by Dave for staff recommendation, including the conditions as presented by staff, second by Heather. All those in favor, raise your right hand, say aye. 1, 2, 3, 4, 5, 6. Those opposed? None. Those abstaining, I'm just going to abstain from voting on this one. So motion passes 6-0. Two of the nicest guys I think I've seen in quite a while here. I would encourage you both to get to know each other.
Yes.
And Chad, as long as you're not doing Alice Cooper stuff,
No, that's not going to happen.
maybe you'll be doing Jimmy Buffett and, yeah, and there'll be a good mojo between the two of you. There are certainly some challenges downtown, but there's opportunities too. And both of you can be a good part of that. Keep up the good work. Thank you. Okay, so that completes that item, so we'll go back to our agenda. Oh, yes, thank you, Heather. Yeah, let's do a 5-minute break before we move on to items 7 and 8. I appreciate everybody's, or 7, what do we got here? 7, 8, and 9, yes. Again, we're paid a lot for this job, so. will. Okay. All right, folks, we're going to gavel back in here. I appreciate everybody's patience today. These hearings are never just, 1 hour and we're out of here. But sometimes we have to spend some time and do the homework that's necessary for everybody's behalf. Related to that, I do have a couple members. This is a great board. Everybody's very dedicated, but Tom had to leave at 3. We're basically at 3. I have another member that will need to leave within the half hour or thereabouts. So we're going to try to move along to see if we can get another one of these out the door. But for those of you remaining on the docket, it always takes 4 members to have an appeal granted. You always have to have 4 yeses. Once we get down to 5 members of the board being present, you got to convince 80% of us of what you want to do. So we do offer appellants an opportunity. If we've got 5 members or less, they can defer their case to next month. But for some of you, if you've already been sitting here for 2 hours and you think you have a good case, and certainly if staff is recommending it, doesn't mean we always follow that, but that's a good indicator that you might have at least a somewhat green light for your appeal. So if anybody that remains on the agenda doesn't feel they can get a good shake from 5 of us, please raise your hand and let me know right now. All right, so if you plan to hang in there, let's hang in there and we'll see what happens. Okay, so we're going to start with item 7, a conditional use request for a bar at 717 Locust Street. Frank will give us the background.
Good afternoon, Chair, members of the board, Frank Dunyoung, planning staff. Item 7 is located at 604 Locust Street. The title holder is Equitable Lofts, represented by Aaron Mesmer. The business, which is Des Moines Athletic Club, is being represented by Nick Tillinghast. And the property, and I'll go through some images here. It's located on what would be the southwest corner of the intersection of Locust Street and 6th Avenue. You can see it in the box here. The Equitable building is the name of the building. It's approximately 19 stories tall. The applicant is looking at Suite 105 for the business. The property is zoned DX1, which is Downtown Mixed Use District. And the appellant is looking at converting the space to a what would be a bar use. The application states that the bar would be a little sports bar in a big building concept. It would have an intimate neighborhood feel. It would typically operate 7 days a week. Their normal business hours would be 4 p.m. to 12 a.m. However, the hours would adjust pending game time scheduling. And here's just another view. You can see the bar, the tables. That's located. I am going to go to the next slide so we can see the exterior of the site. This is an area that has a mix of uses, office, retail, commercial, with upper story residential as well as commercial uses. This view right here is looking what would be southwest across the property. And as I took the photos, I wanted to get a close-up. So there's the front entrance. And then this would be looking southeast across the property. So it is located on the property, which is on a corner, but it would be further west on its property. Here's just another view, step back a little bit. And so we did send out neighborhood notices on May 7th. So those did go out to neighbors within 250 feet as well as to neighborhood associations. The property is zoned DX1 downtown mixed use, which allows the ground floor tenant bay to be a bar use so long as the board grants a conditional use for such use. And so, staff reviewed the request and believed that granting the condition would be consistent with the intended spirit and purpose of the zoning ordinance. The location and operation would adequately safeguard the health, safety, and welfare of persons residing in the surrounding area. We do believe that it's sufficiently separated from residential areas to prevent the business from having any significant detrimental impact upon the adjoining residential. One thing that's different about a conditional use in DX1 is we don't have the same separations that you might see in an MX1 district, where you'd have to have a separation from place of worship, school, et cetera, that you've seen before. Staff believes that the proposed use would not increase congestion in the streets or impair the nearby property values or have a detrimental impact on the use and enjoyment of adjoining properties. Therefore, we don't believe that it would constitute a nuisance if operated in accordance with the recommended conditions of approval, and I will zoom in on those conditions as I have them here. These are typical conditions for bar uses. The first one, basically, we're limiting the conditional use to the tenant bay, which is a little over 1,600 square feet. If they desired to expand, or if there happened to be room, I don't know that there is, for an outdoor patio, that they would have to come back to the board to be granted that. Once again, it has not been evaluated for an outdoor patio at all. I'm not certain that there's sufficient area. Here are the other four conditions. And the applicant did have a neighborhood meeting. They did have some attendees that attended. I'll let the applicant speak to I guess the discussion. It sounded to be positive. And we did receive feedback from some of the people we notified within 250 feet. You can see them in green here, where people did send in comments in support. We did not receive any in opposition. And that is all I have. What questions do you have for me?
Questions for Frank? Okay. Thank you for a good presentation. Good start. All right. Applicant or representative of the applicant, you've got up to 10 minutes. Just need your name, and please sign in on the little sheet there. Tell us what you want to do. Frank will set you up here. Yeah.
Sign in.
That's perfect. Yeah.
Cool.
Hey guys, I'm Nick Tillinghast. I recognize a few of you. It's been about 5 years since I've been in front of you all. I've been doing bars locally since 2017 in this particular neighborhood in general. I have kind of a love for this old block with original architecture, and it frustrates me when there's empty storefronts, and so I'm trying to fill them the best way that I can. I opened Hello Marjorie in 2017. That kind of will give you give you an idea of how I operate. I don't have any issues whatsoever. It's very adult driven. It's very not excess boozing. It's more of a third space. This is just how I choose to do third spaces, and that's through bars. I live in this neighborhood. I live in this building. I wouldn't do anything to my neighbors or anything that I didn't think was not positive. And I know all of them, and they seem to be excited about the opportunity. If you see this little gray area to the left of me, there's going to be a really cool food spot going in there next. Hasn't been signed lease yet, so I can't go into it. There will be a window that goes into my bar, so that way there is a food component as well. So it's not just going to be a place where you post up and booze. There'll be options. So it's my first bar with TVs. I'm excited, and yeah, I'm just trying to add to the neighborhood that I choose to call home.
Questions for Nick? Nick, I think I remember the 2020 meeting you were at.
Yeah, okay.
That was a fun one.
Yeah, I think it was with the old boiler house
Yeah.
that I operate, Secret Admirer.
Yes. Yes. Yeah, and just as a very quick reminder for us, yeah, you mentioned Hello Marjorie, and some you've been a partner with, or maybe aren't now, but yeah, do you have a little list of three, four that you've been involved with?
Yeah, so Hello Marjorie is my first
Okay.
one. I opened Bellhop in the East Village in 2019. Have sold that as of 2022, so no longer under my ownership. Good News Darling, which is right behind Hello Marjorie. It's a little small 26-seat cocktail parlor. And then Secret Admirer on 1110 Southwest 5th. And
Right.
now Des Moines Athletic Club.
Okay. Yeah. I've been into a number of your establishments, first rate.
Thank you.
I haven't seen anybody do it better.
Thank you. I
You bet.
appreciate that.
So wherever you get your ideas, I'm not sure if it's the right bourbon or what, but however that sprouts.
I think it's based off of anxiety.
Yeah, and we have a number of good tavern operators in our city. Yeah, just looks super to me.
Thank
So
you.
no other questions I have. All right, thank you, sir.
I have
Oh,
a-
yes,
I have a
Marla.
quick one. Frank said that you're going to be normally open from 4 PM to 12 AM, but that could vary, so just depending on...
Yeah, I would imagine on weekends we'll be open probably at 11 just to catch the first football games.
Okay.
And that's the only way that in off-season we'll be open at probably 2 o'clock or 3 o'clock.
So it's more earlier hours than later hours?
Yeah, yep.
Okay.
Yeah, no,
Good question.
I never close after 1 AM, even on Friday and Saturdays. I don't want to be a part of any kind of end-of-night issues, and so the latest I ever close is 1 AM.
Okay, all right, thank you.
Yeah.
Good question. Thanks, Marlis. Okay, well, Nick, you can sit down for a minute. We've got a huge audience here, so we'll see what people think. Is there anybody that wishes to speak in support of the applicant's request? Come on down.
My name is Carol Maher. I live in this building at 604 Locust Street in Unit 1605. I haven't officially met Nick, but I know him on Facebook. And yes, when this project broke and it was posted in our closed neighborhood or building Facebook group, people were so excited. So yes, as am I, although I don't really drink, but I'm excited to have the storefront activated, and I look forward to having stuff going on there because that adds to the safety and the vitality that we're all looking for downtown. And as a single woman, I appreciate storefronts that have stuff going on, and I hope that the curtains will be open and we'll be able to see in there so that they can see people outside too. One other thing, as a renter, I don't get notices, right, that go to building owners. And unfortunately, no one from the building was notified of, and we're within 250 feet, was notified of the meeting. So that's just a shortfall, I think, on the notification strategy. If we can't get notified and we live in the same building, it's a little bit of a shame. So, thank you.
Okay. Thank you for coming down, Carol. Appreciate you signing in as well. Anybody else that wishes to speak in support? Anybody to speak in opposition or neutrality? Okay, seeing none, do we have any further questions for staff? Seeing none, we'll close the public portion and go to board deliberation. What do you think, folks?
I'll make a motion.
Okay,
I'll second it.
Staff recommendation.
I'll kind of stick on this side since I was looking that way. So motion by Dave, second by Rhonda, to approve the requested conditional use subject to staff rec. All those in favor, raise your right hand, say aye. All right, motion carries 6-0. Keep up the good work, Nick. You bet. Thank you, Cuckoo. All right, so we're going to be down to 5 members here. So item 8 is a conditional use request at 1020 Army Post Road for use of up to 3,000 square feet of a building for an event venue business. Bert.
All right, Chair, members of the board, Bert Dross, planning staff for the City of Des Moines. This item is a request for a conditional use for an assembly and entertainment small use in an RX1 district. They're wanting to use up to 3,000 square feet of the building for an event venue. Again, the event venue falls under the assembly and entertainment use category, and in the RX1 district that this property is owned, that's subject to a conditional use from the Board of Adjustment. So just a overview of the site. It's located on the south side of Army Post Road, about a block to the west of Southwest 9th Street. If you're familiar with this building, it was built about 25 years ago as a furniture store, as home furnishings for many years. Under the retired zoning ordinance, a furniture store only required 1 parking space per 600 square feet of floor area, and that's why this large building was allowed to be constructed with such a small parking lot. So if you look, according to a sketch that the applicant provided, there's 8 off-street parking spaces to the north of the building. So as I mentioned, they're wanting to use the east half of the building for an event venue. An event venue drives at least 1 off-street parking space per 6 fixed seats. They haven't really provided maximum occupants, or they haven't provided a number of chairs that would be provided, but if it gets that far, they would have to demonstrate compliance with all building and fire codes, and that would be reviewed against the occupancy. But then I also want to point out that the west half of the building would remain as retail, and retail requires 1 off-street parking space per 400 square feet. So if there's a 3,000 square foot retail use here, that in itself would drive the need for at least 8 off-street parking spaces, which is what this property currently has. So I guess as you'll hear as I go along, we are concerned with having an event venue here just on the limited ability to provide any off-street parking. I'll also mention that the property immediately to the east is owned by the same folks. That property has 18 off-street parking spaces, and they're required to have at least 8. So if the board is inclined to grant it, there is a possibility that this property owner could enter in a parking agreement to have up to 10 parking spaces on that property immediately to the east. But just point out that the remaining retail in this building drives at least 8 spaces, which is all they have. So there really aren't any spaces available for the event venue, and then the max spaces that could be provided on the adjoining property is 10. So we do have concerns that having an event venue there while only providing 10 off-street parking spaces could definitely be problematic to the surrounding area, especially when there's not any on-street parking on Army Post, so any parking would have to spill into the residential neighborhood to the south. But here's the floor plan that they provided. Again, north is up. They would have the east half of the building be used for tables and chairs. No number of tables and chairs has been provided, but then the south parts of the building would be used for restroom and then food preparation. They are not wanting to have a liquor license here, so any alcohol would be have to be catered in. This is the elevations of the building. It's an existing building, originally built for the home furnishings furniture store. Here's some photos of the site. The property line is generally where the cursor is here, so there's 8 spaces, parking spaces to the west of that. This is the tenant bay where the event venue would go. This is just the rest of the building. I'm not sure whose vehicles these are because the building is allegedly empty. But anyway, our staff recommendation, we have recommended denial just on the basis of the lack of off-street parking that's available. We feel it could be, the off-street parking situation could be detrimental to the surrounding area. And also, we haven't done any analysis on the building, but it was originally built as a furniture store, so the chances of it being designed to not let sound spill out of the building, that's a very real possibility that it could be a nuisance for the properties immediately to the south as well. So we have recommended denial. Just in our staff in full disclosure, if the board's inclined to support it, we do have some recommendations for conditions to ensure it's not a nuisance, or to limit the level of nuisance it could be. But here's the consent map. All of the cards we got back in were in opposition. Again, concerns with parking and sound. And I didn't point out earlier, but there are residential uses immediately to the south that back up to this building. And these are the cards. Oops. Not sure where I went. So that's
All right.
All I had. Any questions for me?
Hey,
Dave?
Bert, what's the occupancy limit on a building this size?
Well, for an event venue, it's really dependent upon how it's arranged. So I don't remember exactly offhand.
I mean, you always see signs that go maximum occupancy X.
What's that?
Yeah.
You always see signs when you go into places.
Yeah.
What
Fire
would you
code.
guys say?
The fire code would require, would allow up to, if it's standing room only for an event venue, it's one person per 5 square feet. If it's fixed chairs, it's one occupant per 7 square feet. And then if it's tables and chairs, it's one occupant per 15 square feet.
That adds up to a lot of people pretty
Yeah.
quick.
So I'll let the applicant explain it.
Sure.
He has provided some of these numbers, but I would point out, his sketch here shows that about 1,013 square feet would be dedicated to tables and chairs. So you take 1,013 divided by 15. I'm not sure offhand what that is, but that would be how many occupants there could be. Yeah, when he presents, he'll present it.
Let's wait till it's your turn to address the board. Bert, question for you. You've kind of been counting parking spaces here ahead of time on this. Is what's shown here, is this the current layout, or is this proposed to meet site plan requirements? What picture am I
Sure.
seeing?
This is their proposed layout. I noticed that the site plan that was approved back in 1999 actually showed 10 off-street parking spaces here.
Okay.
But I think Mr. Palin can testify that these 8 might be what's actually there today.
And within reason, what's shown here would be designed to meet current site plan requirements for setbacks, landscaping.
Right, yeah. And the change.
So kind of what I'm getting at, there's a restricted amount of parking spaces based on just not only the size of the property, but the requirements in the code.
Correct.
Okay.
Correct.
Because we get a lot of people that just want to, again, we're paved wall to wall from the 60s.
Right.
And now they just want to park everywhere. And it's like,
Right.
no, but, so in trying to count this is
Right.
reasonably about how many cars they'd be parking.
Exactly.
Okay.
And as I mentioned, it's a change in use, it'll drive a site plan.
Yep.
The previous use was a furniture store, which only required 1 space per 600 square feet. Now it's going to retail, which is 1 space per 400, and then event venue, which is 1 space per 6 chairs.
Okay.
So I'd just point out that
Gotcha.
these 8 would all have to be dedicated to the retail, so there would be no or limited opportunity. And as far as the neighborhood outreach, since this is a conditional use, the applicant was required to do a neighborhood outreach. As of this morning, Matt wasn't able to confirm that that had been done. So.
It did happen. The lady has been on the page.
Okay.
Sir, I've got to get you to understand how this process works. You'll have a more than sufficient chance to address this board. I can't have you speak from the audience to try to answer questions for other people. Okay? All right, do we have any other questions for Bert?
And you may not be able to answer this, maybe he will answer that when it's his turn, but are the hours different? I mean, the retail space, is that going to be open to different set of hours than the event center?
It could be. I don't think, unless the board puts conditions limiting hours, I don't know that there would be any limitations on hours.
I was just wondering about parking. Okay, thank you.
Okay, any other questions for Bert? All right. Thank you, Bert. Come on down. It's your chance. You have up to 10 minutes. We need your complete name, address. Please sign in.
I've already signed in. Do I need to sign in again?
Nope. If you're signed in once from your earlier comments, you're good. Tell us about your project.
So she wants to use half of this building for an event venue. I believe that because of the occupant load, they're going to have to add a sprinkler system to the building. So
Hold on a second. Are you the applicant?
No. I'm the representative of the applicant. I prepared these plans for...
Okay. All right. All right. I'm just trying to understand.
What is the name of the applicant?
Yeah. What's your name again?
My name is Matt Palin.
Matt. Okay. All right. Okay. So continue on. Tell us about your project.
So like Bert said, the woman who owns the building next door, so we can use some of that overflow parking. So the lady would have to get a parking agreement with somebody nearby to come up with the rest of the parking spaces, which I think probably can be done. She's looking at only having quinceañeras or office-type events here, not parties in the middle of the night. So, and I don't recall what she wanted to have for the hours of the events. Do you have any other questions?
How long, you own the property?
I do not.
You do not own the property. So what is your role?
I'm the architect.
You're the architect. Okay, fascinating.
My
Okay.
client has been on vacation until last night.
Okay.
So
Okay.
the woman who wants to rent the space has had the neighborhood meeting and only one person showed up, she said to me. So.
Okay. To the best of your knowledge, and if you don't know, that's fine, but, this appears, Bert had said it was a furniture store. Has there been a lot of vacancy here, or they're not able to fill the bays with a normal retail use on a four-lane street?
I can't speak to that.
Okay. That's, and I don't expect you to. But as an architect, to give you credit here, yeah, you tried to design this little site plan to fit the current requirements for landscaping, parking, all that
Yep,
stuff.
I do quite a bit of site plans, so.
Excellent,
Yep.
excellent. Yes. I like to see this versus a napkin sketch, so it's very helpful. Okay. Any other questions for Matt? Okay. Thank you.
Wait, so I take it the woman's name is Vivian? That you're
The
representing?
building owner's name is Vivian, yes.
Okay.
But you don't have a name on the record for who wants to do this event space?
I don't know her name.
Okay, cool.
I've been working with Monica Parra. She's kind of the woman in the middle because I don't speak a lot of Spanish, and the lady who wants to have this space doesn't speak a lot of English.
Okay. Are you the one, Matt, did you sit down with city staff to discuss the project and kind of review before the application was filed?
No, I was not involved with the
Okay.
pre-app meeting. So
Okay.
I came on way after that.
Got it. All right. Well, thank you. Okay. Anybody to speak in support of the applicant? Anybody to speak in opposition to the applicant? Anybody speak in neutrality of the applicant or this issue? All right. Seeing none, any further questions for staff or anything you want to add? Okay. We'll close. Oh, Gary, go ahead.
I don't normally do this, but I think I've got some questions for staff based on what we just heard.
Sure.
About whether this is properly before us. I don't want to do anything that could jeopardize the property owner if we're not firmly convinced that.
And Frank can pull it up. We do have an owner affidavit from the title holder, which is Vivian Pham and Dewey Dang, I believe.
Okay. And have they indicated representation here by, I'm sorry, sir, I forgot, I didn't hear your last name.
Yeah,
Matt.
I don't know that we have anything from them saying Matt Palin will be representing them, but.
But you have a site plan that's already in.
Were they notified that they were going to be on the agenda today?
Yeah, they've received the agendas.
Okay.
So you guys feel comfortable that you've got enough?
Yeah.
Okay, I just want to make sure.
Yeah, and they also own the property immediately to the east, so they were within the notification.
So the owner did call to ask and discuss a little and then the owner filed the application?
Correct, right.
Okay,
Yeah.
okay. Yep. Okay. Thank you, though, Gary. I appreciate that. All right, so we'll close public portion and go to board deliberation.
I'm going to move for staff. If the app can't be here, we don't know anything about this project. These guys, I don't know how committed they are to trying to make it happen, so.
I'll second that. It's so nebulous. It just feels too unclear.
And I do want to throw in before we vote, I live about 10 blocks from here. I'd like to get this bay filled, but I know this side of the street, I know the businesses here. To me, this, without knowing a whole lot of detail, this is way too small of a place for the intended use. Way too small. So, yeah. Well, yeah, and that's kind of what, yes, I think the venue space is small. I know everybody talks about small parties. Yeah, but certainly with parking, you know. This could be a great retail store, you know, maybe even for used goods. So, be that as it may, yeah, the applicant had opportunity to present themselves today. Matt did a good job of presenting the physical part of this, but we've got a motion by Dave and a second by Heather for denial, moving staff rec for denial. All those in favor, raise your right hand, say aye. All right, so that carries 5-0. Staff, I would just encourage you with the decision in order, maybe kind of inform them unless there's some major change in the proposal that, hey, you know, you can't come back for 2 years? Yeah, yeah. But if they can find a way to work with your economic development folks to try to get a retailer in there or a leasee under the current allowances, that'd be cool. It's not up to the city to help people run their businesses, but, you know, if you might think there's a way that somebody could help them out a little, that'd be good. All right, so that'll move us to our last item, conditional use request at 1600 Euclid Avenue. And who's going to kick off this one? We'll see. They're going to fight over it. Just kidding. Yeah. Bert's researching. All right. Frank, give us some background here.
Good afternoon, Chair, members of the board. Item 9 is located at 1600 Euclid Avenue. The applicant that is here today is here in representation of La Fondita, represented by Monica Reyes. They are proposing sale of wine and beer by a limited retail sales business within an existing little more than 1,800 square foot building. As a limited retail sales use, no more than 40% of the receipts could be from the sale from wine and beer and or tobacco products. And so they need a conditional use for limited retail sales, selling beer, wine for off-premises consumption in the MX1 district. I'm going to pull up some photos, some aerials to kind of show the context of the property. It is located on the southwest corner of the intersection of 16th Street and Euclid Avenue. The parcel contains the existing building. It was originally built as a Pizza Hut restaurant and was most recently used for a retail use. The area is, you know, as you can see off to the west, it's characterized by different types of industrial type uses, open space, parkland, but it's bounded to the east by mixed uses, and then residential to both the north and the south of the property. Let's see. I'm going to scroll through some images. And so what I tried to do is I tried to take pictures as I walked east from the furthest west point of the property. So I'm walking along Euclid, and I took a picture of the front, the entrance. As you can see, they've already made improvements to the property. As a retail use, they do not need a conditional use, but since they're adding beer and wine, that's what's triggering the conditional use. So therefore, you're seeing the improvements that are already being made. And this is facing kind of southwest, and then that would be east, and then that would be more northwest. And here is some of their branding. And here is a description of their narrative. Kind of describes, some of the things that they've done to this point. They expect no more than 20% of sales from beer, wine, tobacco. Here is a layout plan that kind of shows the context of the property. So you have registers, you have a beer fridge. The beer fridge is approximately 44 square feet. That would be what is being proposed for their retail beer wine area. To the back, they do have some prepared food areas. So there's, I believe it's cold meat display, view of the food display. The applicant can probably weigh into this, describing it better. They did provide some photos. Once again, like I said, they've already begun making the improvements. So they had to, the premise had been vacant long enough to where they were having to prepare a site plan for the retail use anyway, and so that's why you see some of the improvements being done, and then they're making modifications to the interior, all within allowable use for MX1 district. There's the food areas, another view of them. And so staff we did send out notices to the Highland Park and Oak Park neighborhood on May 7th. Those notices go to property owners within 250 feet and also to all neighborhood associations. The applicant has indicated that the hours of operation would be 8 a.m. to 9 p.m. each week. Now, the MX1 use does allow for a retail sales with beer and wine subject to being granted a conditional use. They, however, have to meet separation distances, and they are meeting those. There's a separation distance of 100 feet, 50 feet from the property line where any place of worship, school, public park, or licensed daycare facility is located. And so staff does believe that the appellant has satisfied the criteria necessary for granting a conditional use. We believe that it's consistent with the intended spirit and purpose of the zoning ordinance. We do believe that the location and operation would adequately safeguard the health, safety, and general welfare of persons residing in the surrounding area. We don't believe that it would diminish or impair nearby property values or have a detrimental impact on the use and enjoyment of adjoining properties. We don't believe that it would constitute a nuisance if it's operated in accordance with the recommended conditions of approval. The use would be consistent with the zoning ordinance, the planning and design ordinance, and the comprehensive plan. And here are the recommended conditions of approval. First one down here at the bottom, limiting them to no more than 40% of their sales to be derived from beer, wine, tobacco products. And here are additional conditions of approval, including their wine and beer area retail would be limited to the 44 square feet that they mentioned. And the one other one that we have in there is that the hours of operation for the retail sales use would be limited to 8 a.m. to 9 p.m. in accordance with our application. Then the others are standard conditions of approval. And we did send out those notices for comment cards. We did receive one comment card from the neighborhood in the far northeast corner. That is their comment card. And the applicant did hold a neighborhood meeting, and here is a summary of that meeting. I'll zoom in a little bit. And it provides some more explanation of their permitting process, food inspection, etc. Here are the attendees. So they had, looks like 7 attendees. And this is a letter of support that we received from what would be the property owner, not the business operator. What questions do you have for me?
I just have a quick one. Are there many other locations that sell beer or wine close by? Or do you know?
And that is something.
Does the radius apply?
The radius does not apply in this situation.
Okay.
However, it's
Oh, I know it doesn't.
it's separated more than a quarter mile from a store that would fall in a similar category,
Okay.
limited retail sales use, or fuel station,
Yeah.
etc.
Okay, thank you.
Yeah, and beyond that, the city doesn't survey beyond the required, like, radius. Well, is there somebody else doing this a mile away or anything?
Right. We typically only apply it to the quarter mile when it's required. However, in this instance, I'll zoom back to the top. And for an MX1, you can see the criteria here is that they get a conditional use, they meet the 150-foot, and then there's
Okay.
40% maximum requirement.
Okay.
Any other questions for Frank? Okay. Seeing none, thanks for the opening. So we've got a patient applicant who's been waiting a very long time today. Thank you for your patience. You've kind of seen how the order works here, so if you'd like to step up, give us your name and address, tell us about your project. You got up to 10 minutes. And then you can sign in when convenient.
Hello, good afternoon. My name is Jacqueline Villafana. I am here on behalf of Inmobiliaria Inc. and La Fondita regarding the conditional use permit. I worked with Monica, the applicant, to apply for this, the conditional use permit. I have been helping our client applying for all the permits and licenses necessary to be in good standing with the City of Des Moines and the State of Iowa. The owners have invested around $80,000 and the landlord has invested around $700,000, including the acquisition of the property. This location used to be an abandoned Pizza Hut. That was a breeding ground for delinquency. Our grocery store will bring life back into the area of Euclid Avenue and restore the economic vitality. So there is a 5-mile distance between Cash Saver and Hy-Vee on Euclid Avenue with minimal options for grocery shopping of fresh staple food items for the community members. La Fondita not only will address the food desert, but will also bring in specialty products for the immigrant communities that make up the vibrant community. Progressive grocery data indicates about 5% of total spending in traditional grocery stores is attributed to alcohol. The section for alcohol at our business consists of a refrigerator that holds beer that measures about 44 square feet. This is the only area in the store that will hold alcohol. Our grocery store focuses to bring fresh staple food items to the Euclid Avenue community. Our grocery store will sell items such as dairy items, eggs, fruit, vegetables, bread, meat, rice, cereal, prepared foods, and many more daily necessities. In order to enhance and heighten security, our business is set to install a per-MAR security system to maintain law and order in our business location and surrounding areas. We will set up garbage bins outside within our store to minimize littering. Our staff is trained with daily cleaning and maintenance habits to upkeep and maintain a clean environment. We will also put up signs for no loitering to increase safety to surrounding areas. We are excited to bring life back into the abandoned area of Euclid Avenue. And are certain that our presence will increase safety in the area. We have reviewed every single requirement for this conditional use permit and agree to 100% comply with these requirements. In regards, there was a concerned neighbor and others. We completely agree about cleanliness and maintaining a beautiful neighborhood. The business owner of La Fondita has owned another business for 15 years that is located on Keo Way, that is a high traffic and a high transit area, and is very accustomed to regular and continuous maintenance and cleaning to uphold high standards of a welcoming facade. If anything, in our experience, businesses like La Fondita bring safety and vibrant community to neighborhood across the metro. That's all I have right now, but thank you.
Well, Jacqueline, that's a great presentation. Appreciate your comments. Board members, any questions? Okay. All right. Seems pretty straightforward. Looks like they've already been investing some considerable money there.
Yes.
That doesn't always mean we'll approve things, but so based on that, yeah, if we don't have any questions, you can go ahead and sit down here. And while I don't think there's anybody present to comment, is there anybody that wishes to speak for, against, or in neutrality on this? Seeing none, any further questions for staff or comments from staff? Seeing none, we'll close the public portion then and go to board deliberation.
Seems pretty straightforward to me.
It's been, I don't remember going to that Pizza Hut, but I remember a lot of them. But yeah, this has been closed for a while, if I remember. And then it drops off right next to it. Kind of a tough parcel, but maybe one of the best fits one could find, have a little neighborhood market here. Yeah, and the alcohol appears far less than 40%, at least on size and scope on the floor plan. So. Staff, right?
I'll second it.
All right, so we got a motion by Rhonda and a second by Marlis to approve the requested conditional use subject to operation under the conditions presented. And I do want to remind you, if we vote yes on this and it passes, we're giving you approval to do it, but you got to do it the right way, because if there are problems, it can come back to us for review and we can remove the allowance for the alcohol. But we want to start you off on the right foot here, so let's take a vote. All those in favor? All right, motion carries 5-0. So it doesn't always pay to be last, but sometimes it doesn't hurt. So thank you for your patience today, and about a week from now, we'll get that copy of a decision in order for your client. So thank you for all the help you've given them. You bet. Have a good afternoon. Okay, so business here, we have to approve our minutes from the April 23rd meeting. If you were here in April, any corrections? If none, would there be a motion to approve the minutes?
Oh, I'll second.
All right. Motion by Rhonda, second by Marlis. All those in favor of approval of the minutes is presented. 5-0. All those present. Do we have any other business? Okay, seeing no other business, this hearing is adjourned. Thank you, officer. All right.